All right, so cases can help us learn. So, given that fact, what are we going to do to work with cases for class? Okay, you've got cases assigned to you as part of your assignment to get ready for class. What do you need to do? Well, the first thing obviously is you got to read them. Okay? There's just no getting around the fact that in order to be able to engage actively in a class, you need to read the cases that are assigned. It's not always fun. It's not always easy. It takes time, okay? But it's essential to prepare yourself to be ready to learn what the cases are going to teach us, and also what the classroom process about that case is going to teach us. So you got to read them. All right, well, how do you do that? Let me make a suggestion. I suggest that first you skim the case. Get a sense of what's going on. All right? And then, after you've skimmed it, so you kind of know where it's going, what's happening. Is it long? Is it short? Is it complex? Is it simple? All right? Then you can do a detailed read. Right? Because at least then you know where you're going. So, skim it once, read it twice. You may find, you know what, I don't have the time to do that, so I got to do one detailed read. Okay, fine. I'm just suggesting that skimming might give you a little extra help when you go through the detailed read. But whether you skim and detail read or just detail read only, what are you going to be looking for? Well, first, what's the factual story going on? And second, what's the legal story? And by the legal story, what I'm focusing on are, first, what's the procedure? Why is the judge or court deciding this case? Is this on an appeal? Is this on a motion for summary judgment? Whatever it might be. Why, what procedure got this issue before the court? Because let me tell you, courts just don't randomly say, I guess I'll decide this case today. No, it's put before the court by virtue of a motion or a trial or whatever. Right? So we can see the procedure. And also, we get to learn what the rule is. All right? So the legal story, we're looking for what was the procedure, but also what was the rule. All right, let's break it down a little bit. We said, okay, well, there's a factual story. What kinds of things are we looking for when we're trying to read a case and analyze the factual story going on? Well, first, what are the facts of the dispute itself? Right? Who did what? What is the plaintiff claiming the defendant did that justifies the relief the plaintiff wants? What is the defendant saying in response? I didn't do that, or, well, I did it, but I also did this other stuff, and therefore my actions were proper. Right? What are the facts of the story that lead to the dispute the court is going to decide? Okay? Now, those facts might not be important in and of themselves, okay? But how do they connect to the rule is ultimately what we care about, right? Because those facts led to the judge deciding that the case would go in a particular way. So understanding what facts are important to that decision is the essence of what we're looking for as we study the factual story. So we're reading it, what are the facts of the dispute, and then what of those facts was important to the decision by the judge? That's what we want to know, because that's what we're going to be looking at as we go through class, and you want to try to understand the case and learn the rule. All right? Okay, that's the factual side. What about the legal side? Okay? As I said before, we want to know the procedural story. All right, so what do we want to know? Well, what court are we in? Okay? And is that court, an appellate court, a trial court? We want to understand where this is at in the court structure that exists within the jurisdiction that we're dealing with. Okay? Is this the highest court of the land or the highest court of the state? Right? Is this an intermediate court? Because that's going to be important in terms of understanding how the precedential value of the case plays out. Right? So what court are we in? And then what is the court ruling on? Is this a motion? Is this an appeal? Is this after a trial? All right? Because that's going to tell us, that procedural question tells us some of the standards that the court needs to apply in making its decision. All right? If it's a 12b6 motion to dismiss, well, the court has to accept the well-pleaded facts as true. If it's a Rule 56 motion for summary judgment, the court needs to look at all the, are there any genuine issues of material fact? And has to interpret the facts in favor, in the light most favorable to the non-moving party. Right? If it's an appeal, there are various standards of review that govern how the appellate court needs to look at the ruling by the court below. Right? So understanding the procedure helps us to understand the rules that apply to the judge or the court that is rendering the opinion you're reading. Right? All right, so we understand the procedure, what court we're in, what procedural place we're at. But now we continue with the legal story, and what are we looking for? Well, what are the arguments of the party? Each party, what did they argue? We need to understand that, because ultimately that's what the court is responding to. That is what the court is ruling on, the arguments that were made. So as we read the case, we want to try to figure out, okay, well, what did one side argue? What did the other side argue? Next, once we understand what those arguments are, what's the rule that the court adopted? Okay. What is the rule being used by the court? Once we know what the arguments are, and we know what the rule is, who wins? What's the result? Okay. And what's the court's rationale for its ruling? Why did it rule the way it did? How did it apply the rule? Maybe it found that an element was missing. Maybe it found that for policy reasons we need to have a new rule. Whatever it might be, understanding the rationale helps us to understand why the court ruled the way it did, and also why the rule that the court adopted should be adopted, should be followed, because the court ultimately has to justify that decision and by argument. And so by reading the opinion, we get to understand where the court is coming from in that regard. All right? So, I know it sounds like a lot, but what you're really looking for is, all right, what are the facts? And what are those facts as they ultimately impact the ruling in the case? What's the procedural posture? And then what were the arguments and the rule that the court adopted? And why the court adopted that rule? The arguments or the rationale in favor of the rule. If we can understand all that about a case, we're ready to talk about it. And we're ready to try to learn by extracting from it the rule, the form of argument that might be made within the opinion, and to understand how, by hypotheticals or whatever, that rule might or might not change depending on the facts of the case. The first time you do this, and may even be for weeks, you will find that this is a slow and tedious process. Most people try to record this information into a case brief. It's good because basically you write it down so that you're ready, you've got it ready, and you can use it in class. Right? There are lots of different suggestions for how to do a case brief, but the key thing is that you're capturing the facts, the procedural posture, and the rule so that you have it you're ready to be able to use during the classroom discussion. All right, so that's what you're doing with the case. And now you want to, having understood the rationale, you want to be able to look at, all right, well, what about the notes after the case? And as I've said in the first video, the notes after the case are important to read. They are not part of the case. They are sort of an addendum. But the notes are important because they can tell us about variations on the rule, or sometimes when there are different rules. They can show us details of the rule. For example, we're going to read a case in landlord-tenant about when the tenant can transfer the lease to somebody else. And the courts that we're going to read, Kendall versus Ernest Pastana is the case, the court gives us a rule. But then having that rule, we might ask, okay, well, what does it mean that a landlord can only refuse to consent to a transfer when it's commercially reasonable to do so? What does commercially reasonable mean? Well, the notes after the case are going to give us lots of different examples of what was or was not found to be commercially reasonable. So the notes can help explain how the rule applies, shows the details of the application of the rule, and sometimes can show variations. So you want to read the notes afterwards. All right? But having done that, you then get a better understanding of this is what this court has said, this is the rule, here are variations or details about the rule. Now I'm ready to discuss it in class. That's the goal of case reading. All right? Now, like I said, when you first start doing this, it seems like it takes forever. Okay? And some cases are a lot easier to do than others. All right? But I want you to trust me that once you learn how to do this, it becomes easier and easier to do. Right? I've been doing this for basically 30 years. I've been out of law school since for 27 years as I record this video. And I know how to pick up a case and find exactly what I need and use it when I'm writing a brief in the clinic or preparing for an oral argument on a clinic case, whatever it might be. I know how to find what I need and to narrow it down and focus in on it. But I got there only by first learning how to read cases in that sort of slow, complete way. And then eventually over time I learned some shortcuts. And you will learn those too. And so it will become easier and easier for you to do. Right? But you got to do it. It's one of those things where it's like riding a bicycle. First time you do it, you might fall and skin your knee. But after a while, you're not falling down anymore. You're gliding along. You're doing fine. And that's what case reading is about. But don't think for a moment that it's not an important thing to do, because cases are the lifeblood of most of the classes that you are going to be taking in law school. Right? Again, either because the cases themselves set the law, or the cases interpret some statute or regulation or constitutional provision so that you can help understand what that source of law really means. So because cases are so central to what we do in law school, and I'll tell you, after 25 years of practice, they are central to what you do in practice. Okay? There are very few areas, there are some, but there are very, very few areas of law where reading cases is not part and parcel of what you do. Because that's important to be able to make the arguments your clients need for you to make. So learn how to do this. Practice it. It will become easier and easier. By the end of the semester, you're going to be able to read a case much more quickly and efficiently than you can at the beginning. So don't give up. You will develop, if you develop good habits, you will develop the ability to get what you need in a more efficient way, less effort. All right?